Hello, everyone. I am Mr. Gonzalez. I will be presenting with my partner.
Ms. Sobrata.
Today, we'll be unfolding the 1993 U.S. Supreme Court case, Zobrest v. Catalina Foothills School District. In this presentation, I will discuss the parties involved in the case, the basic facts, and the legal issues related to the Establishment Clause of the First Amendment. My partner will discuss whether we agree or disagree with the court's decision and compare and contrast a similar court case. The cases involve a hearing impaired student who attended a public high school in Arizona. The student's parents wanted him to have a sign language interpreter to assist him in his classes, but the school district refused to provide him one on the grounds that it would violate the Establishment Clause of the First Amendment. Let's continue with the parties involved in the case. On one side, we have the plaintiff, James Zobrest, a deaf student who attends a Catholic high school in Tucson, Arizona. His parents, Paul and Louise Zobrest, are also parties to the case because they are the ones who advocated for their son's right to a sign language interpreter. On the other side, we have the defendant, Catalina Foothills School District, which argued that providing a sign language interpreter for James Zobrest would be a violation of the Establishment Clause of the First Amendment. The facts of the case are as follows. Because James Zobrest's hearing impairment, he required a sign language interpreter in order to fully participate in classroom activities and communicate with his teachers. Zobrest's parents requested that the school district provide a sign language interpreter for their son, but the school district denied the request, citing the Establishment Clause of the First Amendment, which prohibits the government from establishing a religion. The Zobrist family then took the case to court, arguing that denying their son the sign language interpreter violated his rights under the American Disability Act and Free Exercise Clause of the First Amendment, which protects the right of the citizens to practice their religion as they see fit. The lower court rulings. The U.S. District Court agreed with the school board that the aid provided with advanced religious agenda at the public's expense. This was upheld by the U.S. Court of Appeals to ensure the First Amendment was not violated. In the final ruling of the U.S. Supreme Court case, in a 5-4 decision, the Supreme Court ruled in favor of James Zobrest. The Supreme Court ruled that providing a sign language interpreter for a student attending a religious school does not violate the Establishment Clause as long as the interpreter is a neutral public employee who does not provide religious instructions or participate in religious activities. Implied that the interpreter's role was different from that of a religious school teacher. The legal issue in the case was whether providing a sign language interpreter to a deaf student attending a religious school violated the Establishment Clause of the First Amendment to the United States Constitution. The Establishment Clause prohibits the government from establishing a religion or favoring one religion over another. The Individual with Disability Education Act is a federal law that requires public schools to provide free and appropriate education to students with disabilities. The school district argued that providing an interpreter for students attending a religious school would violate the Establishment Clause because it would use public funds to support a religious institution. The Supreme Court ruled in favor of Zobrist, holding that providing a sign language interpreter to a deaf student attending a religious school did not violate the Establishment Clause. The court reasoned that the interpreter was provided to the student, not to the religious school, and that the provision of the interpreter did not amount to a government endorsement of religion. The decision in Zobrest v. Catalina Foothills School District had several effects. First, it ensures that students attending religious schools would have access to same educational opportunities as their peers in public schools. Second, it clarified that providing services to students with disabilities attending religious schools does not violate the Establishment Clause as long as the services are provided to the students and not to the religious institutions. However, the decisions also raised concerns about the possibility of public funds being used to support religious education. Critics may argue
My partner and I came to the conclusion that we both agreed with the verdict that was finally decided at the end of the case. The case was a significant legal decision that clarified the role of public schools in providing services to students with disabilities in religious schools. The ruling was based on the findings that provision of sign language interpreter was neutral. Secular circuit services that were required by the IDEA and did not have a primary effect of advancing or inhibiting religion. Individually, we believe regardless of where they attend school. However, other opinions could argue that the district should not provide services in religious schools, even if they are required by federal or state law, because it could be seen as an endorsement of religion. The principles of separation of church and state and the understanding of the First Amendment and ultimately values and perspectives of the court ruled in favor of the petitioner.
In comparison to our court case, Zobrest v. Catalina Foothills School District, there are two cases that are very similar in the context of the Establishment Clause and the Free Exercise Clause. One of them being Witters v. Washington Department of Services of the Blind for the Blind and KDM-XREL WJMV Reed Sport School District. Starting off with Witters v. Washington Department of Services for the Blind. At the time, Witters was attending a private Christian college seeking to become a pastor, missionary, or youth director. The commission denied his aid on the ground that he was prohibited by the state constitution, and this ruling was upheld on administrative appeal. The petitioner then brought an action in state superior court, which affirmed the administrative ruling on the same state law grounds. The Washington Supreme Court affirmed but based his ruling on the Establishment Clause on the First Amendment. It was decided that providing aid to the blind student did not directly interfere with the state sponsoring religious endorsement. Now to transition to the next compared case to Zobrist v. Catalina Foothills, the KDM-XREL WJMV Reed Sport School District was holding in accord with the free exercise analysis of school districts' accommodations of a child with disability. WJM son, KDM, was a minor who was legally blind and has cerebral palsy. As a child with disabilities, they are entitled to special education and services under Individuals with Disability Act, IDEA. Oregon provides the services to children enrolled in public schools. This becomes a discrepancy when it comes to private or religious-oriented schools. Oregon administrative regulation leaves individual school districts to choose whether they provide such services to those students enrolled in private schools because they would like to maintain a religiously neutral setting. The defendant, Reed School District, was willing to provide the services to KDM, but not to his school, which was a private school. This was decided that this would violate KDM's rights under the free exercise, establishment, and equal protection clauses of the Constitution. It was then determined that the Department of Education should allow children with disabilities to receive these services provided regardless of the location for the delivery of these services. If a child has disability, they are eligible from the ages or grades of kindergarten through the age of 21 to be offered appropriate public education or private accommodations to their disabilities. This works hand in hand with Zobrest v. Catalina Foothills because it is still an argument to this day whether or not private schools should allow students to have their disabilities be understood and accommodated for. I hope this presentation summarized the importance of understanding the Establishment Clause as well as the Free Exercise Clause, depending on state constitution and school districts all around. With Zobrest v. Catalina Foothills and Witters v. Washington, as well as WJM and KDM, it is important to understand that we should be able to have access to the proper care for children with disabilities as well as adults with disabilities.